Greetings and salutations, my fellow sovereigns. This is the Wednesday night Vocational Science of Freedom Open Roundtable. And tonight we're going to have some discussions about an interesting notice that was dropped onto Maricopa County, Arizona. It was posted by Ann Vandersteel, and I will take a look at that notice and give a synopsis and a reply as to how I would have improved it. And we will also go over the changes that we've done to the VSOF Gilded server, just so that everybody knows where to find everything. And if you'd like to join the Vocational Science Freedom Gilded server, you can do so for free. And the link is gilded.gg/VSOF, which you can find on the Vocational Science Freedom YouTube page. And it's in all the show notes for all the classes on YouTube and on Rumble and on Odyssey. So with that, let me pull up the server here and take a look at, well, actually, first, let's go to the post on X. So Mr. King dropped this today in main chat, and this is from Ann Vandersteel. And I don't really know a tremendous amount about this woman. There were some people that have come to me in the past and said that they'd spoken to her and were exchanging documents and ideas. So I still don't really know who she is or what her background is. She seems to me, to the best of my knowledge, to be a logical and true freedom fighter. But so my knowledge of her is limited. That's all I kind of wanted to say as a little bit of a caveat here. So as it reads, breaking: Maricopa Board of Supervisors just ran out of a public meeting when they were served the following, which is not surprising that public officials run out of rooms. I've had judges do this. Other people I know have had judges do that. Sometimes cops leave you alone fairly quickly, too, if you say the right things. And certainly little boards of supervisors, county boards, and all the little local people who are not in some sort of protected bubble by either billions of dollars or surrounded by their own paramilitary. They tend to get a little bit nervy when you start to throw around words like treason. So, my name is Michelle Clan, and I'm here today to put you on public notice and to inform you that you are not our elected officials. None of you have ever signed an oath to the Republic of Arizona. Instead, you have signed an oath of office to a foreign corporation, which means this is an act of insurrection. You do not have a proper bond carrying surety for your actions to we the people. Due to all the voter fraud, you have never been formally voted in. Acting as if you have any authority over the people is a direct act of treason. Today, we the body sovereign are presenting you each a notice of liability and opportunity to cure. The fine is $1.75 million per claim, and there are 12 signatures, which means you are each personally liable for $21 million. If you do not resign in 3 days, you will be presented with a writ, that should be a writ of quo warranto, and a waiver of tort. If you do not rebut these truths and you remain in office, we will be notifying the military, and your act of treason will be grounds for an immediate military tribunal. I do not need to tell you the penalties for treason. We, the body sovereign, hereby command you to resign within 3 days, or else face the consequences. I'm also here today to hand you this jump drive, which contains a 5,000-page document notifying you of all the dangers of the vaccine and the poison in the water, to name a few. These are high crimes and acts against humanity. If you cover up high crimes, you will be held guilty for committing acts against humanity. Therefore, I hereby command you to send a public broadcast to every resident in Maricopa County, notifying them of these dangers within the next 3 days, or you will be in direct violation and derelict of your supposed of duty. That they must have misprinted that, making you even more accountable for your actions. Notice to agent is notice principal. You have been formally served on record. So I'm thinking that they might have said this because this beginning part clearly sounds like they were speaking, but it could have all been written down. I'm not exactly sure. So anyway, I took a look at this and I took the time because it was dropped in main chat. So I took the time in main chat to give a fixie fix because some of this is correct and some of it is a little bit off. So I said, not bad. Now let me fix this quick. And hopefully this is big enough for everybody to see. I don't think I can actually make Gilded any bigger. So I will just kind of reread what's in here. So all additions will be in brackets and all revisions / deletions will be in between two little knives. And all of my comments will be in italics. Okay. So my name is so-and-so. I'm here today to put you on lawful public notice by we the people of Arizona. Because if just one person puts you on public notice, that doesn't really matter. If a whole group of the body politic of we the people put you on notice, that's something different. And to inform you that you are not our elected officials. None of you have ever signed an oath to the Republic of Arizona, as is required under, and then insert constitutional provision that requires same. Every single original constitution for each state has a clause within it that deals with this issue. So, put it in there. To fail to put this in is laziness, in my personal opinion. All right, now, just get rid of this instead. Okay, if you have signed an oath of office to any foreign corporation, prince or principality, this shall be seen by we the people as an act of insurrection. If you, get rid of just the you, if you do not have a proper bond carrying surety for your actions to we the people, and are not and cannot be public officials. So, right? So if they don't have the bond, so don't say you automatically don't have bonds because that's an accusation. Say, if you do not have proper bond, you are not and cannot be public officials. And by the way, you know what I think I might do here? I might just simply put this next to each other if I can do this. So we can kind of go a little sidey by sidey here. Okay, there we go. That's better. Due to all the voter fraud, of which we have proof, it is impossible for you to ever have been formally voted in. Because the way that they said it, they said, due to all the voter fraud, you have never been formally voted in. Okay, that's like a statement of fact and also an accusation. So what's the better way to do it? Because if you're putting someone on notice, if this is actually, indeed proper notice, then what you say is that we've got proof, so it's impossible for X to have happened, right? That's how you should do it. So to continue, acting as if you have any authority over the people is a direct act of treason. Okay, well, this is my comment on this. Well, even if they were properly voted in, they still would not have any authority over the people. And the statement would imply that they would, had they been properly elected. So really that whole sentence shouldn't even be in there, or they should reword it, because it implies that they would have some sort of authority. And sorry, folks, but we live in a republic. We the people are always sovereign. There is nothing, no law at all, that the government that we created can create to have authority over we the people. Now, can governments enact public law? Sure, but public law always has to do it with a harm. And ultimately, who actually prosecutes public law? Well, we the people, because you do so in a 25-member grand jury, and then that's an indictment, and then the accused has the right to a jury trial of 12 members of the peerage, also known as petite jury, to defend themselves for the prosecution, meaning we the people, or whoever happens to be prosecuting the case. It could be one of the people, or it could be a actual prosecutor for the state. That's fine. But they're acting always from a standpoint of we the people that are prosecuting it. Because you will also find this in every state constitution. I think, anyway, I've never seen one that doesn't have this. It says that all process shall be in the name of the people, or something to that extent. Or sometimes it's written out like completely formal, shall be in the name of the people of Arizona, or whatever. But there's always a clause in the Constitution to state that. And why? Well, because we, the people, made sure that when those constitutions were created, that all process had to be in our name. It was never going to be in something else, the name of something else. Like, oh, the state of Arizona decides to come after you. Nope, sorry, can't do that. So, proper process is always laid out in the original constitutions with that clause. Okay, to continue. We today, the body sovereign, are presenting you each a notice of liability and opportunity to cure. The fine is $1.7 million per claim. There are, and I put not 12, but 25 signatures, which means you are each personally liable for $21 million. Now, this would not, and this is my comment on this would not automatically make them liable. If they were to fail in their reply and the rest of the accusations be found to be true, then yes. If you do not resign within 3 days, you will be presented with a writ, that should be writ of quo warranto, and a waiver of tort. Now, that should be an action of tort at law, not a waiver of same. Furthermore, they need to file said writ, meaning who's ever doing this, they need to file the writ of quo warranto with the Arizona Supreme Court, where I'm quite certain, as Arizona would be the same as pretty much every other state, if you read the Constitution for the states, it will state where high prerogative writs should issue out of, and it's always the Supreme Court. So, if you're going to do a high prerogative writ, do it properly. Place it into the Supreme Court and have the fucking thing issue. And if you do it right, the Supreme Court's not going to balk about it. They're there to do what they're supposed to do. And particularly, got 25 doing it, well, then there really isn't anything they can say about it. So, do a proper high prerogative writ. Have it issue out of the Supreme Court. So it's got the little stampy and seal and all that good shit. And then go do your deal, okay? Then you serve it on them. Then they have the requirement to reply, and you follow all of the procedure that deals with high prerogative writs. Or whatever, you deal with the procedure of whatever high prerogative writ it is. So in this case, quo warranto. I would also add to that, which I didn't put into the main chat, I would also add mandamus to that list, because quo warranto is basically, it means by what authority, and mandamus means that you're setting down a mandate, or the writ is filing as a mandate to say, hey, stop that, whatever that is. So I would do both kind of hand in hand. So, all right, to continue. If you do not rebut these truths and you remain in office, we will be notifying the military, and your act of treason will be grounds for an immediate military tribunal. And I said, add the DOD Law of War Manual section that applies. Then, next section, I don't need to tell you the penalties for treason. And then I said, actually, you do. They are life in prison or death. And I would, without hesitation, have stated that in the notice. And you could even put the particular section of law, whether it be the Arizona Constitution or whether it be the Constitution of the United States of America, wherever it's stated, go ahead and put it in there. Because what you want to do every time that you give notice is you state your facts, you state your evidence that you have, or even, present it, and you state the law, and you then give opportunity to let them get off your toes. And then we, the body sovereign, hereby command you to resign within 3 days, or else face the said consequence. That should be consequences. Sorry, I didn't put the S in there. I'm also here today to hand you this jump drive, which contains, because that's all fine. These are high crimes, acts against humanity, and treason against the state of Arizona. That's my addition, because they're talking about treason. Well, yes, you can commit treason against the state. Okay? So, look it up. I know it's in the original Iowa Constitution. I'm pretty sure it's in the original Wisconsin Constitution. And I would be kind of surprised if it's not in Arizona as well. But it may not be, but does that matter? No, because the people can bring an indictment for treason against the state anytime they wish to. So, and then I axed the whole thing here. But what I said was, if you cover up acts of high crimes and treason whilst acting on behalf of a foreign corporation, prince, or principality, you will be executed as a spy under the law of war. Because that's the actual penalty if you go and read the DoD Law of War Manual. Because here's the thing. And I've reread this thoroughly in the DoD Law of War Manual because I couldn't really believe they'd put it in writing somewhere, but it kind of makes sense. I just didn't really know the military law before I read it. So if someone is acting for a foreign prince, principality, corporation, whatever, but they do not identify themselves as basically being on the other side, right? Because we all got to identify ourselves here. If we're at war, which, sorry, folks, we are, and basically have been under martial law since the Civil War, the history of which I don't want to get into, but point is, when you're at war and the law of wars apply, everybody has to show their color. Why do you think these cops are out here in these goofy-ass uniforms? It's because if they're not showing their color. They're not saying who they're operating for, right? If you don't do that, you can be hung as a spy. And I don't see anybody in county board meetings saying, hey, this is who we're representing here. They are working for a foreign corporation or that they are actually working for a foreign prince or principality. They're not exactly, saying it. So that applies. Okay. At least the cops have on their goopy ass uniform and they've got their flag that has their yellow fringe around it. Basically the East India Trading Company flag with the yellow fringe on it saying, okay, hey, this is who I'm working for. Okay, great. At least I see you as a soldier of the enemy side. Okay, fine. Wonderful. But, I'm supposed to be at peace with you because the United States is supposed to be at peace. This was all settled a long time ago. So I don't know why the fuck you're coming at me. But anyway, and no, I don't have any contracts with you. Go fuck yourself. But anyway, that's a whole discussion for another day. All right. So to continue with this little thingamaboy. All right. So I axed the whole next part. So the therefore part. So to redo it, therefore, you are hereby commanded by the people of Arizona to cease and desist all actions made by you under color of law within 3 days, or have that should be aforementioned. Sorry, not a forenoted. I got to fix that. I wanted to say the aforementioned, but actually, I guess either one doesn't matter. The aforenoted actions taken against you by the sovereignty of this state, which is we the people, right? Because the way it read before, therefore I hereby command you to send a public broadcast to every resident, and it shouldn't say resident, it should say all people domiciled in Maricopa County, that's what it should say, notifying them of these dangers, and these dangers we're speaking upon the water and the vaccine within the next 3 days, or you will be in direct violation, derelict of your supposed duties. It shouldn't be your supposed of duty, making you even more accountable for your actions. Okay, well, here's the problem. You can't require that one perform a duty that you just proved that they don't have, right? So just boot them, meaning just say that they're not there. Just get rid of them, which is why I rewrote it the way I did. Therefore, you are hereby commanded by the people of Arizona to cease and desist all actions made by you under color of law within 3 days, or have the aforementioned actions taken against you by the sovereignty of this state. That's how that should have been written. Notice the agent is notice the principal. Fine. You've been formally served, and all of these matters shall be recorded onto public record. It just said you have been formally served on record. Well, what record? Right? You're not being very specific there. And then in the end, I just made a comment. I will say that people are getting better at this, but they still have some things to learn, which is fine because we all do. So that was my little fix of this drop that supposedly they did. I mean, hopefully they did it. It's good that they're noticing the agents of foreign powers of these things, but needs a little revision. So does anybody have any question, comment, or alteration of anything else you think I should have added to that?
I just want to say that there's a guy in Arizona named Dave Jose, and he didn't write that, but it sounds like a Dave Jose notice. And this guy has been very effective. It's kind of blowing me away because just through notices, they're not even affidavits. They're able to really get some feathers ruffled. And he was real principal in the Arizona election there with I forget her name, Katie something, but Yeah, he's getting a lot of traction just with a notice. I don't really understand that. I thought they had to be affidavits
No, I can
and this
explain
and
that.
that.
No, you do everything originally, everything in law as per proper due process always starts with a notice. Now, does a notice do anything? No, it just puts the other party on notice of what you know and what their actions have been, possibly against you or for you or whatever. That's literally the starting of all manner of due process. You get a notice to go to court. You get a notice to cease and desist. You get a notice to do XYZ, right? You get a notice that you're being sued, right? Everything starts with a notice. Unless, of course, you can do things directly at common law by an original writ, but you'd have to know how to do that, and not a lot of people, even judges, even understand how proper common law process even works even more. But yes, proper public notice is what should happen. Do you have to have an affidavit with it? No, you don't. Particularly if you're doing it as a grand jury, or if you're doing it as the people, as they did here. Now, I suggested that they alter the signatures to 25 instead of 12, because then you'd be acting as a grand jury, and that's a whole different animal than just because technically you say 12 signatures. Well, okay, you're saying you have 12 signatures as a petite jury. Well, that's all well and good, but you can't create a judgment by a petite jury simply just because you want to. So it's not a judgment. It's just a notice by 12 people. Is that better than a notice by one person? Sure. Would a notice by 25 be better? You betcha. So yeah, it makes sense that you would get traction from properly created, lawful notices, because you are telling them what you're doing and you're telling them what the law is, and that's fine. So yeah.
So with our document set, they get snared with 90 days to kind of reply. This guy's asking for just 3 days. Can you explain that?
Yeah, when it comes to things like this, when you catch somebody red-handed in the act of impersonating a public official, you don't have to give them a grace period of 90 days. The reason why I've done it the way I've done it in the doc set is because of all the accounting and everything that would need to happen in order for proper livery of the estate to be given back to us if they choose to do what they should be doing by executive order within the doc set, because there's a lot to do. But in a matter like this, they're saying, no, you're not even a public official. You're impersonating a public official. Get out of here. You don't need to give them all that amount of time, because it's technically criminal actions right up from the bat. Now, not to say that what they're doing regarding the administration of our state also is not a criminal action in regards to probate fraud, tort, executor daison tort, unlawful administration of an estate, common law theft even. I mean, we want to go that far. So not to say that what they're doing is not criminal actions to us. However, they've been operating this system for so long that they really don't realize what they're doing as far as the true liability of it, which is why they should get served the doc set and be put on notice. Just like, and to mention another gentleman that also gives notices that scares the shit out of people, Cal Washington in the Empower movement, he does the same thing. He gives these companies, the power companies, notices of liability to remove the smart meters off the sides of people's houses, because it does cause damage to the DNA based upon the frequency that they use for smart meters. So from my understanding, he's even served CEOs of certain companies and they've resigned over what he's served them, which makes sense, because technically once you get served with notice like that, they can't change the operations of the corporation. I mean, I suppose they could, being a CEO, but there's no way they would ever do that. So instead they resign, because they're like, no, I don't want to be hit with this amount of liability, which they would be if they continue to stay there, and which these people would be if they continue doing what they're doing in here. Now, of course, should they re-perfect this notice and do it the way I wrote it? Yeah. Is it still official from the standpoint of what they did? Yes, but obviously they're missing what they're missing based upon what I fixed. But anyway, so yeah, they have 90 days as far as what we serve them. But again, that's more along the lines because of the enormous amount of accounting that they have to do to fulfill the executive orders and the VSOF status docs.
So if we came in with a notice of imminent trespass and then served them the doc set or an expanded ordinance of the estate and gave them 3 days to either reply or deny or whatever, would that be a way to give them proper notice of what they're getting themselves into?
Yeah, it would, but I mean, you're already doing that with what's in the doc set anyway. There's no real necessity to. I mean, here's the way you should do it based upon how the doc set's set up. You should serve them, and then after 30 days, send them a second notice. Then after another 30 days, send them a third notice. Then after the 120 days is up, then you can serve them a default notice and have it do a notary presentment of a default notice after that. Because in a sense, that's really the way that you should do it to cover every single jurisdiction of law. Because under the law merchant, there are times when you could use a notary to do a notary presentment because the notary acts as an officer of the court and the state recognizes them as an officer of the court. And so then when you do the default notice, you are already locked in completely for going in and doing at least an equity claim, basically a default claim, because that's what the IRS does to everybody. They go 1, 2, 3, knock, knock, knock. And here you're coming to court and the matter's already settled because you did it in basically in maritime admiralty law merchant procedure, which is the 3 knock and then a default as to what they didn't do. But the thing you can't do, and the thing I want to make very clear to people about the incorrect process of what some people have been teaching for years, unfortunately, is that what Amaru said, the automatic default judgment by acquiescence, you can't automatically do a default judgment by acquiescence. What you can do is default them. You can default them by what's called administrative procedure. That's the 3 knock thing. Knock, knock, knock. They don't reply. And then you give them a default notice. That's called administrative procedure, and you can default them by that. But that is not a judgment. Okay? That gives you the capacity to then go into an equity court and then get judgment. But it doesn't in itself create a judgment. And that's where a lot of people fuck up. They think that somehow or another, I don't know how they ever got taught this, but they think that failure to reply automatically creates a default judgment. It does not create a judgment. It creates a default procedure that you have defaulted them in an administrative procedure, which then allows you to go into an equity court and get a judgment, but basically a summary procedure, because there is no summary procedure at law. Summary is just something that's only at equity, but this is how you get it done. So as far as what Emery said, Webster's estoppel in law, a stop, a plea at bar, grounded on a man's act or deed, which estops or precludes him from averring anything to the contrary. So yes, you state in your notice that if you do not reply to X within a certain amount of time, you are thereby estopped, meaning you gave them an amount of time, you told them that they'd be barred from doing anything else. And you can do that based upon your own estate property because you are basically writing law in the status doc set from your own house saying you're going to be estopped if you don't answer me here. So what else you read? If a tenant for life levies a fine to another, it shall work as an estoppel to the cognizor. Do it according to the law of negotiable instruments. Notice, yeah, basically, right, yeah. Notice of default, notice of protest, non-acceptance payment, default judgment by acquiescence. Yeah, it's the 3. Yeah, that's. Yeah, I think that's notice of default. No, you don't do a notice of default twice or second. It's notice. I think the second one is, you can call it like a second notice with opportunity to cure, and then notice of protest, non-acceptance payment. Yeah, okay, that would be fine for the third one, and then the fourth one, your default notice, because it's never a default judgment. It's a default notice, which then creates the capacity in equity for basically a summary procedure and a judgment from an equity court. So that's how that's properly supposed to do. And don't take my word for it either. Make sure to go and read a treatise on equity procedure and learn these things. This is where I learned them. And everybody who's joined the Vocational Science Freedom Guilded server has access to the VSOF online library treatise folder. So I suggest you guys use it. Okay. All right. So if there's anything else? Yes, no? If not, I will just do a quick run through the Guilded server here just to give you guys an idea of what happened and how things got shifted around a little bit. So,
Hey Zen, I just have one more question and comment.
Yeah, sure.
So with this notice, how can this really have teeth? I know that there were some heavy words in there and they left the room, but how can it really, be put into effect?
Okay, so you want to know how the remedy plays out. Okay, so based upon what they wrote here, okay, there'd be a long list of remedy, okay, any of which or all of which they could do, or which I'll put it this way, of which I will state to you guys for the record on here based upon what they wrote. All right, let's put it that way. Okay, so just off the top of my head, just kind of rethinking about this, they could and should go to the Arizona Supreme Court and have the Arizona Supreme Court issue an original writ of quo warranto and mandamus and serve them. They should also convene a grand jury. They should notice the chief judge of the county, Maricopa County, that they are forming a grand jury, whether he likes it or not, or she likes it or not. And I wouldn't even tell the chief judge what you're forming the grand jury for. It's none of their damn business anyway. So, and I would also notice the sheriff of Maricopa County as well, stating that we're forming a grand jury. And again, you don't have to tell the sheriff what you're investigating because it doesn't have to be known by anybody because the grand jury is meant to meet in secret anyway. So you create a grand jury, you start investigating, you gather all this evidence of all these things that they made accusations of in the notice, but you gather the evidence. You say, all right, do they have an oath of office? No, they don't. And if they do actually have signed an oath of office to a foreign corporation, okay, prove it, right? Just bring the evidence in, make it part of the indictment, and lay it down. Also lay down every other thing that you find that proves any other accusation or statement made herein into the indictment from the grand jury. Then you would give the indictment to the DA of Maricopa County and say, here, prosecute. Now, most likely under Arizona statute, there will be criminal procedure of which he is required to follow by law when he gets an indictment dropped on his desk. My guess is he or she probably will not act. When they do not act, meaning when the DA does not act according to law, you wrap the district attorney up in the indictment and say he is neglecting his duties, and then you take the indictment to the chief judge and you take it to them with all 25 of you walking into his court when he's holding motion hearings for the day. Catch that motherfucker off guard. Okay? You don't have to make an appointment with him. You can walk in when he's holding open court. Go up to the bailiff. Say, bailiff, we have something, meaning we, everybody behind me, and you don't even have to say grand jury, just we have something to present to the judge. Give this to the judge. Well, what is it? None of your business. Give it to the judge. He has to then hand it to the judge. The judge then has to read it and go, oh shit, because he realizes, because two things will happen right then. The chief judge will realize that you already went to the district attorney and they failed their duties. And so, sorry, buddy, you're the next one up the chain. And if you don't do it, and he'll realize right then that if he doesn't do it, he's the next one on the list, right? And then it doesn't matter. Then if the judge won't move either, then you wrap him up, put him in the indictment, and then you simply prosecute. You can prosecute the entire case in front of the full grand jury if you want to, or you have the grand jury foreman act as special prosecutor and ring them all in. So that's how you would run it if you were going to run them over with a grand jury. Some of these other things in here you could do for remedy. Let me think. You could do a common law tort as far as damages are concerned. And you could bring the whole bloody county in on that one if you wanted to. Just post it in all the conspicuous places, put it in newspapers, and blast it all over the place. Put it up on a bulletin board or something that, hey, anybody in the county want to join this tort? Come along. So you could do that. So that'd be a tort damage. And tort is always an aspect of common law. So it'd be an original action at law for tort in a court of record that proceeds according to the course of the common law. Then you logically follow all that out. Okay, so that's all that. Then, all right, now the military aspect of it. Okay. So if you go read the DoD Law War Manual, it will state in there, in a few places, that all courts are commissioned courts. Well, what the fuck does that mean? It means that technically they're all military commissioned courts. Okay. Now, does the Maricopa County Board of Supervisors, are they technically running a military court? No. However, if they are indeed doing all these things of which this notice accuses them of doing, would they be subject to a military tribunal? The answer is yes, particularly under the aspect of what I said regarding failure to show your colors. Then that's the whole spy issue. And then, yeah. Why? Because, as I said, the military has been in charge of protecting the Republic since the Civil War, and they technically need to start doing it. Okay, so how do you do that? You would first take care of all of this remedy that I already just spoke about, pretense. You take care of all that first. If that doesn't go anywhere, or you even get paramilitary pushback, say someone sicks the city cops on you or something, or somebody has their little jackbooted thugs that come and try and, hunt people down or something. Start to jail people just because they are holding a grand jury or doing what they're doing here. Then you would immediately take every single thing that you have. Facts, evidence, law, timelines, proof of service affidavits, everything you have, and you go to the provost marshal of the region of whatever Maricopa County would be in. You find the provost marshal for that, and you lay it down on his desk, and you say, look, we are all here as people of Arizona. Get it, buddy? We are not here as citizens of the United States. You are required to protect the Republic. And then point to him in the DoD Law of War Manual where he needs to act and tell him to get busy. Okay? And if he won't do it, well, then you just go up one chain of command and keep knocking on the door. If, and this is a big if because I'm the kind of guy that needs to have it proved to me, if indeed it is true of what some people are saying, that the military is in control, that Trump is the actual commander-in-chief, that he never passed a football, so on and so forth, all the sealed indictments, say all that be true. Okay, fine. If that be true, if you do exactly what the fuck I just said, they should instantaneously act when you get to the provost marshal, right? Because they should be waiting for it, supposedly. So, that would be a good way to prove or disprove every single bloody thing that has ever been thrown out on Q and all these other people that talk about what supposedly is going on, like 107 and many, many others, right? Maybe even Ann Vandersteel herself. I don't know. The point is, you want to get it proven? All right. Properly walk through the proper process to do these things. Because the only way you find out if it is actually going to work and that people are waiting for this to happen and that the military is on our side and so on and so forth, all these things that we've been hearing through the grapevine, prove it. It's your duty. We the people. Not anybody else is going to do it. That's for sure. And no one else can do it. Now, this is a very good start, I will admit, right? But I don't think I forgot anything. Let me just real quick run through, see if there's any other remedy that I kind of forgot about. Okay. So Maricopa County Board of Supervisors, if you threw in the whole poison in the water thing with fluoride and threw those facts in there, that's a hell of a lot more liability, because then you're talking about the liability of the entire population of the county. So there's that. What else? Oh, you can also indict them for treason against Arizona, because yes, you can commit treason against a state, as I said before. So there's that, which would just be grand jury again, and the people would just do that. That wouldn't be a military thing. Oh, if everybody fails to act and no one does what they're supposed to do, you can summon the militia. Just summon 100 able-bodied men that all understand the law of what. Now, okay, granted, that might be a little bit difficult to do, but just have them listen to this class and say, here, right? And realize that they can do this. And then also, if people don't realize that they can do it, make sure that you go and watch the clip that I grabbed regarding the power of the people for the militia. And you go to self-defense in the VSOF YouTube and look for the pretty girl in the bikini holding the firearms and watch that. It's very, very important congressional record regarding the capacity and the ability of the militia to do whatever it is the hell they need to do. It's clearly without the need of permission for or from anyone in government. So, okay, so that's all that. Anything that I post onto any of my platforms, feel free to share with anybody else that it might help or might give ideas to. And if anyone listening to this wishes to have a discussion with me, they're always welcome to join the Guilded server and just send me a DM. I mean, yes, you have to answer the questions to get in, just so I know you're not glowing, but other than that, that's fine. Or anybody can also contact me at vsof@protonmail.com. And they can also get a hold of me that way if they want to have a discussion about what else can be done. And then I can give them all of the information, all the treatises, and have a roundtable with them about how you get this done, because it seems to be the process that people are not quite getting. So okay, let me open this up and take a look at this, whatever Emery wanted me to look at. Okay, this is from Understand Contract Law, and you win. Okay, this guy's got some things right and some things wrong. But anyway, I'm sure he probably didn't mess up his maxims. Workman is worthy of his hire? Yes, true. All are equal under law? Yes, true. Of course, and this is an aspect of the law, meaning, obviously natural law and the common law. All are not necessarily equal under statutes, but that's another thing. Sorry, did you want me to actually go through this guy's comments and make a point here of where this guy might have erred? Is that what you want me to do with this?
No, I mean, I just thought maybe take a look at it and see what you think, because it's just showing the commercial maxims and how if they don't respond to them, especially on a public record, then they stand as truth.
Yeah, under the law merchant, under maritime amnesty law, yes, I'm not arguing that. It's when you get into the aspects of torts and when you get into the aspects of treason and these other things that are not under that particular jurisdiction of law and have never been adjudicated under that particular jurisdiction of law is where you start crossing these maxims. Because there are maxims of equity, which are only for equity. There are maxims of common law, which apply to common law and equity. And then there are maxims, technically, of the law merchant that really only apply to the law merchant. So you have to apply a maxim in the correct manner. It's not like every maxim fits every keyhole, if you know what I mean. There are some that are specific to certain jurisdictions of law. So, and it doesn't look that long, so I can kind of go through this. Okay, so a workman is worthy of his hire. I would say that applies to every single jurisdiction, right? All five.
Including our fee schedules, correct?
Yes, exactly. That's precisely why we have a fee schedule in the doc set, is because, look, if you're saying, what you're saying with that is, with any fee schedule, that's your board on the wall. Like, somebody say walked into McDonald's. Where's the fee schedule? Oh, it's right in front of me. It's the board on the wall. It's called the menu. So you give them an order, which is, you're all in a common law jurisdiction here. So if you give a man an order in a common law jurisdiction, he has the right to present you with what? A bill. Exactly. And is that lawful? Yes, of course it is. That's what you do when you walk into any restaurant. Now, people don't think about it that way, but that is what you're doing. So you walk in. What's the menu? Oh, it's the fee schedule. Oh, you want to give me an order? Okay. Well, your superiors have already been process served properly, and have had plenty of time to argue this as far as what my fee schedule is. So just know that there is a proper fee schedule filed on the public record. Your superior has been served with it. And if you are going to give me an order in a common law jurisdiction, of which I am in, thank you very much, because I don't have any lawful contracts with the corporate state that would give you capacity or ability or authority over me otherwise, right? So you're going to have to pay my fee. So workman is worthy of his hire. Bam. Yes. Applies to all 5 jurisdictions and most definitely the fee schedule. Second, equity before the law, or more precisely, all equity under the law. Yeah. No one is above the law. Fine. This is founded in both natural and moral law and binding in everyone. It was also an aspect of Norse law and all of the white European tribes prior to Rome. For someone to say the access to above law is above the law is insane. True. This is majority insanity of the world today. Okay, I'm not going to read all this rest of his rantings. Number 3, in commerce, truth is sovereign. Yeah, when you're dealing with the law merchant, you're dealing with maritime amity law, and even to extent equity when it deals with contracts or trusts. In commerce, truth is sovereign. Sure, I think there's quite a few maxims that I think would be stated better, but okay, fine. All right, 4, truth is expressed in the form of an affidavit. Well, can be. Truth can also be expressed in the form of indictment. Truth can also be in the form of a notice. Can also be declaration. Yeah, exactly. There's a whole bunch of things that you could put in there. It does not only mean that it has to be in an affidavit. So this is the one that bugs the shit out of me. People drop this one and they're misinterpreting it to think that it's only an affidavit that you express truth in. No. No fucking way. What are you thinking? It doesn't even make any sense, right? It doesn't make any sense at all. I mean, if this were absolutely true in the way that they're trying to interpret it, then what? A constitution isn't truth? I mean, come on now, right? I mean, your Bible wouldn't even be truth, because is the Bible an affidavit? No. I mean, come on. They're thinking about it in the wrong way. Okay. So anyway, an unrebutted affidavit stands as truth in commerce. Okay. Now I don't have a problem with this one, but they do have to apply it only in the proper jurisdictions of law. You can't take this maxim and then go throw it into common law. Sorry. Doesn't work that way. An unrebutted affidavit stands as truth in commerce. It does under the law merchant. Yes. That's why there's the 3-knock rule. That's why you have an administrative process in maritime amity. Because it's been unrebutted. You gave them 3 opportunities. Knock, knock, knock. You didn't say anything. Okay. So, nah. Now you've defaulted. And by the way, just to make a point about the 3-knock rule. I might have said this in some other class, some other time, somewhere, but I'll make a point about it here. The reason why there are 3 notices is the following. It's because of ships. Someone, say in Italy, sent something, say to Greece. Say they sent 100, let's make this scenario. And let's go back to say, let's say 1812, whatever. So in 1812, one man sends 100 barrels of olive oil from Italy to, say, Greece, right? Gets to a Greek port, ship pulls in, the port authority says, "Where's your manifest?" Captain says, "Here it is." Port authority says, "Okay, you're bringing in 100 barrels of olive oil." Captain says, "Yep." They start to unload the ship. Turns out there's only 90 barrels of olive oil. Well, Port authority notes that. Port authority says, "I only got 90 here. It's not 100. It's only 90. Captain goes, shit. You're right. Well, then what happens? Well, the guy that ordered the bloody olive oil has to do what? He has to say, "Hey, wait a second, Italy. The guy I contracted with in Italy, you forgot 10 barrels. Right? Okay, how does that happen?" He creates a notice and he sends it back with the captain or the next ship bound for said port. right? Notice gets there. The guy who he contracted with reads it. Says, hey, you only sent me 90, not 100. And by the way, here's the signature of the Port Authority stating that they only counted 90, not 100. What's up? Now, that guy, the guy he contracted with, can either send a notice back saying, nope, fuck that, I had 100. And by the way, here's a witness stating in an affidavit that he saw and counted 100 barrels on the ship. Okay, if he does that, who's at fault? Who has liability then? The captain. Because magically 10 barrels disappeared from Italy to Greece. Whose problem is that? The captain, right? He could do that, or he could say, oops, you're right. Thank you for the notice. I'll send you back another notice. Your 10 barrels will, or I didn't have, let's say this. Let's say he didn't have the 10 barrels. Let's say you only had 90 barrels and somebody else, was slow with their delivery or something, right? Okay, let's put it that way. He'll send a notice back saying, hey, yeah, got your notice. Here, notice this. You'll get your 10 barrels on the next ship. Sorry, my delivery didn't get here on time in order to get to you on time. Sorry for the inconvenience, right? Here's an extra 2 barrels or something like that, right? Whatever. Notice for notice. So we keep going back and forth with notices here. If he sends back the notice and he says, nope, I put 100 barrels on there, or say he says, I don't know what you're talking about. Let's say that. Let's say the guy in Italy says, basically, in a sense, go fuck yourself. I don't know what you're talking about. Okay. The guy in Greece waits a while, waits, 30 days, which strangely is kind of the norm now. And back then it was probably a little bit longer. But again, let's not go pure laws of Oleron here. Let's just get to the point. That it would go back and forth 3 times. If he sends 3 notices and no response is given from the contracted party, he is then in default. He then sends him a final default notice of which a notary would then sign off on. He then can take all of those notices with the default from the notary public to a judge in his jurisdiction under maritime amnesty law, also under law merchant, and get a judgment. He can then send that judgment back to the proper executive officer in the area or the county, the jurisdiction in Italy, and say, go get my shit. And that was it. That's how you do that. But the final step is going to the court and getting the judgment, people. It doesn't just auto magically happen with one guy not properly responding to one affidavit. Okay? That's how this works.
You do it before a jury too, right? Like a common law jury.
You can. Yeah, you could bring the whole matter before a jury if you wish to. You can technically bring equity matters before a jury, but you don't need to. Because when you've got a default like this and you're in a maritime amnesty / law merchant jurisdiction, you don't have to convene the jury. Because under that jurisdiction of law, that's how shit works. But people keep confusing these different jurisdictions. It's like trying to mix water and oil. I mean, no pun intended with the previous analogy, but that's the issue. And people keep doing that. They do it with Maxims. They do it with procedure. They do it with writs. They keep doing this. I don't know why they do it. I guess they've just never learned the law properly. But you can't do that. You shouldn't do it. You should know better, by the way. You're sovereign. You should learn the law and do it right. But, when you do it right, okay, fine. You can use that. But just know what you're doing, right? All right, number 5. None of butter. Okay, yep, same kind of thing. Again, commercial. And none of after it becomes the judgment in commerce. Again, based upon what I said. Yes, as long as that process is done. It's not just one affidavit, right? The whole thing has to be completed. In commerce, for any matter to be resolved, must be expressed. Yes, this is a matter of due process. This is why everyone shall not be denied due process, because you cannot go and get a default on somebody that you've never noticed. Okay, what's this doing? 1.8. What's the next one? He who leaves the battlefield first loses by default. Please do me a favor and show me where that's a maxim. Unless he's just talking about it being a maxim of war, then okay, but that's not a maxim of law. 1.9, sacrifice is the measure of credibility. No willingness to sacrifice, no liability. Responsibility is authority your measure of conviction. What on earth? I've never seen that before, and I don't. Oh, nothing ventured, nothing gained. Okay, that's not the proper maxim. That's not the way that maxim is actually written. Let me think of it off the top of my head or see if I can remember it. One of them is, I believe, he who has not been damaged has no claim to remedy. I think that's how that one goes, which is kind of akin to this. The other one, I think that's a little bit closer to this one. It's either like one must give equity to have equity, or reverse that. One must have equity. One must give equity to have equity as a remedy. I'm kind of butchering that one, but it's something like that. What it basically means is that if there's been no lawful consideration exchanged, if there's no lawful contract, if there's no promise of equity to begin with, one cannot go scream and holler for equity and get it in court, is more or less what that means. So in a sense, no contract, no obligation. You kind of, can do that. That's kind of what this one is more like. But I've never seen this. Sacrifice is the measure of credibility. Nah. Show me where that one actually exists. Written this way. 1.10. Satisfaction of a lien. Okay, that's not a maxim. In commerce, a lien or claim can be satisfied in any one of three ways. By someone rebutting your affidavit with another affidavit of his own, point by point, until the matter is resolved as to who is correct in case of non-resolution. Well, here's the thing. This is so ridiculous. Okay, you don't get a lien. You can't make a lien. It is unlawful to create a lien against anyone unless you have a judgment against them already. Okay? Does everybody get that? Is that clear? Because you will be charged with a crime if you start going around and liening people without a judgment. That's stupid. It's a complete violation of due process. It's completely wrong on every single aspect of law. And you're a moron if you do it. Now, if you have a judgment, yeah, you can file a lien. Sure. What does that protect you? It protects your property so that they can't go sell it. Meaning it locks it down, says, no, there's a lien on this. There's a clouded title, if it be land or, say, house, something, whatever. That's what a lien does. It protects you. It locks it down and says, no, you can't go sell that because I have a judgment against you. That's why I can lien on your stuff and say, don't sell that. In a sense, you can literally think of it physically. You can go lean up against somebody's house and say, nope, you're not selling this, or go lean against somebody's horse and say, nope, this is my horse until you pay me my money. I'm leaning on your horse here, right? You can literally think of it in that physical standpoint, but you can't do a lien without a judgment. God, where do people get this idea? Anyway, legal maximum. Plaintiff not prove his case, the defendant is absolved. True. Now that is a proper maxim. 10. So the 10th maxim is a lien or claim can be satisfied only through A lien or claim can be satisfied only through rebuttable by. This doesn't even make any sense. Rebuttable by affidavit, point by point, resolution by jury, or payment. No, a lien cannot be satisfied through a rebuttable affidavit. Because again, a lien is after a judgment. So you're not satisfying something by an affidavit when you got a lien, a lawful lien against you. That's not accurate. A lien or claim may be satisfied only by resolution by jury. No, because if you have a lien against someone, you've already had a judgment, so you can't. It's already res judicata. Or payment. No, the only way to satisfy a lien by previous judgment is payment. That's it. Done. So anyway, so this guy again has got a bunch of stuff half right and half wrong. So again, just all you guys do yourself a favor and just look stuff up, and by God, please get your maxims directly out of a law dictionary like Bouvier's, right? So let's not mess that up anymore. Okay, we've already gone past an hour. I guess I will talk about what I redid on the server at another date. Yes, Maria, this class will be posted on Rumble and on YouTube and on Odyssey, as always. And again, just as a reminder, anyone like to join the Vocational Science Freedom Guild server and hang out with us in our classes and interact with us in our chat rooms and share information, you are free to do so by going to gilded.gg/VSOF. And next Saturday coming, we will continue our reading of the book, The Great Taking, and it will be part 6. Part 5 is already recorded. I just need to edit and post. But part 4 is up for everyone's viewing enjoyment. So please make sure to share that. And the whole series, by the way, is now on the playlists for all platforms. So you can just share the playlist with someone so they can get started from the beginning and learn how the attorney is about to steal the world. So with that, hope all of you have a wonderful rest of your week. Thank you for joining in. Thank you for learning, taking the time to ask questions. And until next time, as always, stay safe, stay sovereign.